Hello, and welcome to today's session. Thank you very much for joining us. My name is Miruna Poenar, and I'm counsel in the corporate department here at CMS Luxembourg. With me are Joan Parmentier, Senior Associate, Cornelia Krajewska, Associate, and Julie Boutlinger, Associate. Today we're looking into directors' activities in Luxembourg and aspects related to their liability, which are of particular and growing importance in the current geopolitical and economic context. Now, these days, before approving a transaction, managers are expected to do more than simply consider the basic traits of an investment. And more often than not, they're actually expected to perform an intense scrutiny of numerous factors, such as, for instance, ESG parameters of an investment opportunity, or they are required to factor in the impact of inflation on financing an acquisition, or more generally, they are expected to take into account the economic or political stability or instability in a particular region. So as part of our guidance today, what we aim to do is to help you identify certain risk factors that it's good to be aware of, and then we will offer you some recommendations meant to guide directors through these challenging times. Now, should you have any questions during today's session, please do not hesitate to ask them by either uploading them onto the chat or by sending us an email. We will be happy to consider each question and revert with answers after the webinar. I will now let my colleague Cornelia guide you through today's topic. Thank you.
Thank you very much for attending this webinar. As mentioned by Miruna, we will talk today about directors' duties and liabilities. Our presentation is structured as follows. First, we will give you a brief overview of main duties and rights of the directors. Second, we will explain what are the liabilities of directors. Third, we will give you some general recommendations and tips. Fourth, we will analyze the increase of risk factors. And finally, we will end our presentation with recommendations and tips to apply in challenging times.
Now let's begin with an overview of the main directors' duties and rights. Directors of a company must ensure that they act all the times in the interest of the company, but what does it mean for corporate interest? The term is not defined by the law. Several interpretations of a corporate interest have been proposed, and we retain two different concepts. The narrow concept, it is a restrictive interpretation, and it's when you consider only the common interest of the shareholders. And the broad concept of a corporate interest is when you take into account the interest of the company, shareholders, debtors, and employees. It is the common interest of all persons that interact with the company. So how should this concept of corporate interest really be interpreted? There is no clear choice between the two concepts. But you need to be careful of the various interests and give the priority to the company interest as a whole. In brief, the company must be managed in its best corporate interest and fulfill the corporate object included in the article of association. In this presentation, you will also discover that acting in the best corporate interest also means adapting to new challenges, such as environmental and social issues. In addition, the director has a duty of care and must execute his mandate with honesty and must comply with a standard of conduct as a reasonably prudent person. The lack of competence is not an excuse. Due to their positions, directors have a duty of confidentiality and must ensure that information about the company remains confidential and that people with access to this information do not disclose it. Director must ensure that all formalities applicable to the company provided by the law and the articles are complied.
Another important duty of the directors, especially in the challenging times, is to regularly check the financial situation of the company. The board should check the losses in the annual accounts and in each interim accounts prepared during the year. If, as a result of losses, the net asset of public limited liability company fall below half or quarter of the share capital, there is an obligation for the board to convene a general meeting of the shareholders to resolve upon the continuation of the activities of the company. In the event of non-compliance, the directors may be declared jointly liable towards the company for all or a part of the increased losses. The principle is legally applicable only to SA, but can be applied, and it is recommended, to SARL, private limited liability company, on a voluntary basis. Moreover, the director must abstain from taking part in the deliberation in the event of conflict of interest. It means that the director who has an interest, direct or indirect, of patrimonial nature, which is contrary to the interest of the company, in relation to a contemplated transaction, he or she should inform the board immediately. Such conflict of interest should be recorded in the minutes of the board's meeting, and the shareholders must be notified at the next general meeting. Finally, every director has a duty to represent the company and to participate in the decisions making. However, the directors have not only obligation but also rights. Each director has right to have access to information about the company's affairs. In case of holding companies, director has right to request financial and commercial information from the managers of operational companies. Directors have also right of inspection. They may inspect, take copies of the books and accounts of the company at all reasonable times. Directors have also right to be assisted by an expert. They have also rights related to the participation in decision making, which means that they have a right to receive transaction documents sufficiently in advance of the board meeting in order to be able to review them and consider the transaction. They also have right to be notified in advance of the meeting and to vote, which is at the same time right and obligation. Now we can move to the director's liabilities. We will start by reminding some general principles. General principles are the following. Director's liability may be either civil law liability or criminal law liability. Civil law liability may be either contractual, vis-à-vis shareholders and the company, or tort liability, vis-à-vis third parties. It is important to understand that there is a non-option principle, which means that there is no possibility to choose between contractual and tort liability. Finally, it is important to mention that in order for a director to be held liable, three conditions must be fulfilled simultaneously: fault, prejudice, and causal link between the two.
We have also the liability for mismanagement, which is based towards the company and based on the contractual liability with the three conditions already explained by Cornelia. This liability arises from the contract of mandate entered into by and between the company and the directors. As such, only the company will be in a position to invoke this type of liability. The mismanagement may consist in an action or in an abstention, for instance, the failure to collect receivables that are due and payable.
The directors may be held liable for a breach of the company's articles of association or breach of the company law, like breach of the corporate object of the company, signing without having power to do so, non-compliance with the rules of the allocation of powers between the various bodies of the company, absence of keeping company's book and records at its register office, failure to submit the annual accounts in time. In this context, we would like to draw your attention to an important instrument of protection of the minority shareholder, which is called minority action. The minority action is available for the shareholders holding at least 10% and no more than 51% of the voting rights at the general meeting, and that have granted the discharge to the directors. It is important to underline that the minority action can be brought only against one specific director, and it is not necessary to act against all directors.
We can now turn to liability in tort. Third party can sue directors on the basis of a general principle of tort liability of the Luxembourg Civil Code. The principle is that directors are not directly liable to third parties for the acts performed on behalf of the company, but the company is. But we can underline the fact that directors do not have total immunity from third parties. According to some Luxembourg case law, directors can be held liable in tort toward third parties if they have committed a serious personal fault. This is the French concept of faute détachable. It must be intentional, serious, and incompatible with the normal exercise of the role of directors. The rules governing the previous liability regarding the time limits are the following. The prescription is 5 years. if the act giving rise to the offence is an act related to the director's duties. The starting point for this 5-year period is the time at which the offence was committed, or in case of fraud, at the time at which it was discovered. The directors can be liable even after resignation if the cause of the damage lies in acts committed during their mandates.
In the challenging times, it is recommended that the directors regularly evaluate the company's finances. This should include regular board meetings and duly considering all the options available, including state aid, exceptional support measures, preventive procedures, or any other alternatives to avoid or at least mitigate possible financial difficulties. In the challenging times, the directors must apply increased diligence. Actions taken prior to the commencement of a bankruptcy can be scrutinized by the creditors and the company's receiver, who can bring action against the directors. In this context, it is important to remind you that the company is considered bankrupt when two conditions are met: when it has ceased payments and when it's unable to obtain new credit, either by getting a loan or by postponing deadlines of its current commitments. The directors are obliged to file a petition for bankruptcy within 1 month from the moment that those two conditions have been met. That being said, the directors may be held responsible for company's debts. This can happen if the bankruptcy proceedings reveal that there are insufficient assets to satisfy the creditor's claims. In this case, the commercial court can decide that the directors can be held liable for the company's debts, in full or in part, if they have committed a gross and manifest fault leading to the bankruptcy. A gross and manifest fault is understood as a fault so serious that it could be viewed as being close to an intentional fault, although it does not necessarily need to be intentional and may result from the director's incompetent conduct. For example, absence of any reaction to the company's difficulties, entry into a transaction which jeopardizes the company's financial situation. Moreover, the bankruptcy may be extended to a director who has been particularly dishonest. Extension of insolvency means that a director can be declared personally bankrupt. As a particularly dishonest behavior, we understand, for example, a situation when a director is masking his actions under the cover of the company to carry out commercial acts in his personal interests. Finally, directors may be prevented from engaging in any commercial activity or from acting as director or auditor of a company if they have committed a gross and manifest fault contributing to the bankruptcy of the company.
Directors can also be liable for non-payment of taxes. This may be due to non-payment or insufficient taxes, or it may be due to fault on the part of directors leading to non-compliance with tax obligation. In the event of non-payment, the tax authority issue a guarantee called tax assessment to the director and determine the amount of the company debt for which the director is personally liable. This is the end of the part 2. Now Joanne will give you some recommendations and tips.
Thank you very much, Julie and Cornelia. That we've seen the general duties and rights of the directors, we will give you some general recommendations and tips to mitigate the risk of potential liability for directors of Luxembourg companies. First of all, it is really important to hold the board meetings when the business requires it, and on a regular basis. You should really avoid having 1 or 2 board meetings ratifying the transactions. COVID pandemic really changed the way meetings are held, and the use of Teams and Zoom platforms is the way board meetings can be held. Therefore, the directors have the possibility to meet on a short notice and on a regular basis, and to invite the relevant people very easily to present topics at the board meeting or to question managers of the underlying assets. You should also make sure to carefully record the discussion in the board minutes. You should devote time for the management of the company and review the documents in advance of the meeting so you can ask the relevant questions and make sure that the question and answers are clearly recorded in the board minutes. You should actively participate in the meetings and ask questions regarding the nature of the documents to be signed and of the envisaged transaction. It means in practice that you should be cautious about the number of mandates that you have. It is also very important to always have the interest of the company in mind when approving a document and transaction. You should carefully assess the corporate benefits of the company. For example, you should check in the documents if there is a limitation of liability clause for the company and if its content is appropriate and standard. If you have a conflict of interest, you should mention it at the very beginning of the meeting and abstain from taking part in the discussion and in the vote. You should also inquire about the financial situation of the company and the business evolution of the activities of the subsidiaries. You should be able to request the presence of someone from the management team to give an update on the performance of the subsidiaries. In the event of distribution, make sure that the company complies with solvency rules, and you should be surrounded by professionals. As mentioned before, the lack of competence is not an excuse, and you cannot be an expert in all fields, so you have to seek advice when appropriate and request updates on a specific topic. If you no longer agree on the activities performed by the company or do not follow the business strategy, you should consider resigning. You should make sure that this decision is filed and published ASAP with the Trade and Companies Register, and you should make sure that a discharge is granted to you at the next annual general meeting of the shareholders. If the company is not able to meet its obligation and is no longer able to obtain financing, you must file bankruptcy petition in due course. In case of financial difficulties, be careful regarding any transaction requiring the valuation of assets and also the terms of payment. Make sure you are covered by a management liability insurance. We will now briefly talk about some of the new challenges which are faced by the directors, and we'll give you some additional recommendation at the end to mitigate the potential liability risk. During the past 3 years, we've seen, several COVID lockdowns affecting the economy. We've seen war in Ukraine, creating economic instability and supply chain disruptions. We've seen an increase in the cyber risk, in particular with ransomwares. But we've also experienced an increase of environmental issues, which can potentially impact the financial situation of the companies. The legal framework is also evolving quickly with a lot of new compliance, tax and ESG rules, for which the company may take actions, if not today, in the near future. It might be relevant to ask questions about the potential impact of an investment on the environment, or if the subsidiary has a ESG policy already in place and what is the content of such policy. Even if we are not aware of similar actions in Luxembourg for now, we have seen in Europe and in the US certain actions against directors in this context. For example, an action brought against directors in case of a cyber breach and the failure to protect personal information of customers and employees. Or an action brought against the directors of Shell for their climate strategy, which, according to certain shareholders, puts the global energy company at risk as the world transitions toward net zero. There is also a famous case in the UK where directors have been held liable for selecting a supplier in Asia who has later been in spotlight for using child labor in the fashion industry. The customers obviously turned their back on the company, resulting in a sharp decrease in the volume of sales. All these events and rules might put a lot of company into challenging financial situation, and as a consequence, their directors are facing an increase in the risk of personal liability if they do not fulfill their duties properly. But it's not always easy to predict the impact and consequences of such events and new rules. This is why we prepared a list of recommendations and tips, which is specially designed to help you react in challenging times. Our first recommendation is simply to have a more proactive role in the management of the company. And why do we mean by that? We mean taking the lead on requesting board meetings and inviting experts, or requesting the presence of an investment manager or CEO, CFO of the subsidiaries. You should ask specific questions on the impact of a particular event or a European directive, and you should make sure that your questions or answers are properly recorded in the minutes. You should be able to ask questions even via email to the managers of the subsidiaries, or to the service provider of the company, or to the investment managers regarding the cash position of the group, critical payments deadline, or in general about the evolution of the business and the group strategy to face a particular challenge. You should also be even more careful about the company's interest. For example, in a situation when you had a temporary bank loan and your shareholder is now willing to grant you an intragroup loan to repay the bank loan, it might be seen as a good idea to get rid of a bank loan, but what about the interest rate of those loans? If the bank loan was concluded in 2019, the interest rate was probably very low compared to the interest rate of the new intragroup loan, if you follow the market. It is even more difficult to predict if there is no clear indication of the interest rate in the new loan. And for example, if the interest rate is defined simply in the intragroup loan as being determined by a transfer pricing study. Make sure your valuation of assets is properly made. Consider hiring an expert in case of doubts. You should also take time to assess the financial situation of the company, identify the risks, liquidity issues, and potential capital impairments, and ensure that there is no breach of commitments under certain important agreements. You should also make sure to have an IT policy in place and that access to the facilities to the building is properly controlled. You may also put in place a written procedure, guidelines, or protocols in order to react in case of crisis. It can be a very straightforward document for each type of incident, for example, in case of cyber attack. But make sure your employees are properly trained and know how to implement those protocols. Make sure also that the local management team is implementing the appropriate government measures to protect the employees' health. Last but not least, be surrounded by professionals and carefully review the terms of your insurance policy. To conclude, directors should not only have a passive role, which mainly consists in approving whatever transaction falls on their table, but they should carefully assess the corporate interest of the company and have a very proactive role in challenging situations. It is one thing also to be a prudent and diligent manager, but it's even better when you document it. So make sure the minutes reflect your questions and remarks. Thank you very much for your attention, and feel free to drop us an email or to write your questions in the chat box. Our next corporate law webinar will be next week on the 22nd of June, and the topic will be what to expect from the implementation of the Mobility Directive in relation to cross-border conversion. Have a very nice day.